So we have a major escalation in the legal fight to dismantle the NFA nationwide after the $0 tax change. The Trump DOJ recently filed another brief defending the NFA, and they tried to break some rules and sneak in some new evidence. But now the plaintiffs have fired back, not just with some legal arguments, but also with some brand new hard evidence showing that the ATF is actively denying Americans their Second Amendment rights right now, even after the new $0 tax law. This new supplemental evidence exposes something very huge for this case. The ATF is not running a shall issue system like they claim. It is exercising some open-ended discretion and still denying these applications. So let's break down what exactly just happened in this case and why this could be devastating for what the government is arguing in favor of the NFA. Now, before we jump into this video, if you guys want to support the channel, one of the best ways to do that is simply to subscribe. Also hit the like button, that tells the algorithm that you appreciate this content and it should share it to more people. I also want to take a second to thank one of the main supporters of this channel, which is First Form. You guys know that First Form is an amazing company. They're pro-freedom, pro-America. They support the Second Amendment and what we talk about here on the channel. But also maybe if you have a New Year's resolution and you're trying to get healthier this year, you're working out more, check them out using the link down below. I use their supplements every single day after I work out, like their protein powder, even some of their energy drinks and stuff like that. So again, check them out using the link down below. And if you order any supplements, you can get a free 5-pack of protein sticks. So if you've been following the channel for a while, you will know that this case here that we're going to be talking about kind of exploded after Congress reduced the NFA tax to $0 under HR 1, the Big Beautiful Bill. That new law and the new law that's applied to the tax essentially applies to suppressors, short-barreled rifles, short-barreled shotguns, and AOWs, and has taken the tax from $200 to $0, and that's currently in effect. Once that tax was eliminated, multiple groups moved to actually challenge the rest of the NFA and get rid of the remaining restrictions. GOA, Gun Owners America, FRAC, Silencer Shop, Palmetto State Armory, Silencer Co., and others filed a lawsuit against the ATF. They were also joined by over a dozen states, which included Texas, Alaska, Georgia, Idaho, Kansas, Montana, Oklahoma, South Carolina, Utah, West Virginia, and Wyoming. Now, the core argument in this case is very simple. If there is no longer a tax, Congress loses its taxing power and justification for the remaining NFA restrictions. And so again, without that tax, the NFA's registration and transfer scheme exceeds their federal authority. Now, because of this and this lawsuit, both sides are now trying to end this case right here and now through cross motions for summary judgment. The DOJ wants the court to uphold the NFA right here and now, and the plaintiffs want a ruling that the NFA's registration scheme is unconstitutional as applied to suppressors, SBRs, SBSs, and AOWs, again because there's no longer a tax. In its original brief, the DOJ made four main arguments for why the NFA and its remaining restrictions should still remain in place. First, the DOJ claims that even with the $0 tax, the registration scheme is still valid because of the special occupational tax on dealers and manufacturers. Second, the DOJ argues that the NFA is independently justified under the Commerce Clause. Third, the DOJ insists that even if the plaintiffs win in this case, the relief that is granted should be limited only to the named plaintiffs, not to everyone nationwide. And finally, the DOJ claims that the NFA does not violate the Second Amendment because it's a presumptively lawful shall issue licensing scheme, which is allowed under Supreme Court precedent in New York State Rifle and Pistol Association versus Bruin. So here the DOJ makes a big argument saying that this operates as a shall issue permit, similar to a shall issue CCW license, and therefore it should be allowed. Now it's this last argument here which is now in serious trouble and was just exposed by the plaintiffs with new evidence that they got from what the DOJ and the ATF have been doing in regards to the $0 tax change. After plaintiffs responded, the DOJ filed its reply brief also to this case and attached a brand new ATF declaration. That declaration claims that the registration scheme is still essentially needed because the ATF allegedly denies hundreds of applications each year over tax compliance issues. So they're saying the only time they really deny these are based on tax compliance issues. But under the North District of Texas rules, you can't introduce new evidence at this reply stage without permission. The DOJ did not ask for that permission. Instead, they just tried to sneak in new evidence. The plaintiffs argue that the DOJ already submitted evidence earlier in this case, and it's now trying to fix some of the holes in their case and in their arguments after seeing what the plaintiffs did in their brief. So in simple terms, the DOJ was trying to sneak in and get a second bite at the apple after they saw that their arguments were weak. But also, these new arguments that they tried to make with the supplemental brief that they tried to sneak in with these new, pieces of evidence, that was also just exposed with new evidence and new information that was found by the plaintiffs like GOA. So here's where things just got really interesting today with this new evidence. In a separate supplemental filing, the plaintiffs introduced real ATF records showing how the NFA actually operates in practice currently now, even with the $0 tax change. This new evidence shows that an ATF examiner denied 2 Form 1 applications, one for a suppressor and another one for a short-barreled rifle, and the reason for that denial was pretty shocking. And that essentially was a denial because the applicant wrote that they wanted to exercise their God-given right. That's all they said for their reason. That was the justification that they put forward for why they wanted that suppressor and that SBR. And the ATF marked the application disapproved for providing an insufficient reason for wanting a suppressor and an SBR. They did not say that, it violated the statute, no regulation reasons, no standard really at all. It was just pure discretion. The examiner did not like that the person said that they wanted these items to exercise their God-given rights. Again, that just sounds like pure discretion for that denial. This new evidence destroys the ATF's shall issue claims in this lawsuit and why they say this supports the NFA. The DOJ told the court in this case already that the NFA is a shall issue scheme like the ones that were permitted under Bruin. But Bruin is very crystal clear, shall issue systems must have narrow, objective, and definitive standards. They cannot grant open-ended discretion to the examiner like here in this case, and they cannot require a special need to exercise your Second Amendment rights. So here what the ATF did is the exact opposite. They are saying that, you wanting to exercise your Second Amendment rights is not good enough. Instead, you need some sort of special need or some other qualification or reason to get these items. That is not shall issue permitting. That is purely discretionary licensing. It goes against Bruin and also contradicts what the ATF already said in this lawsuit, that they are not, doing discretion or anything like that, that this is operating as shall issue. But again, this shows that they are in fact still using discretion to approve or deny these type of items. That alone is a Second Amendment violation. And it proves that the plaintiff's broader point is correct, that the NFA is not a neutral registration system that operates as a shall issue permit like the ATF and the DOJ are claiming. It is an active barrier to exercising constitutional rights with discretionary barriers that the ATF is still using. So where does this leave us in this case? Well, we now have a $0 tax on these NFA items. The DOJ is scrambling to save the remaining NFA restrictions. They're claiming that this is shall issue. They even have a procedural fight right now over some improper evidence that they tried to submit in this case. And now also you have documented proof by the plaintiffs that show that the ATF is denying applications based on unconstitutional discretion, which they said they do not do at all. So this case is no longer theoretical. It now shows the court how the NFA operates in the real world and why it cannot survive under Bruin and also now the $0 tax change. It also cuts one of the big arguments out from what the DOJ was making about why this does not violate the Second Amendment. They wanted to frame the NFA as a shall issue permit, but here they have express evidence showing that there is not a shall issue permit. There is still discretion going on where they say you have to have a special need or some sort of qualification that the ATF approves of for you to essentially get these items. So that's where things stand right now in this nationwide NFA challenge. So as soon as we get more information, as this updates more and as the ATF responds to this new evidence, I will let you guys know. If you like this video and you would like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. But as always, thank you so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.